Court expansion, better known as packing the court, became a hot-button issue in September 2020 after the death of Justice Ruth Bader Ginsburg and the nomination of Justice Amy Coney Barrett. This April, President Biden created a commission to explore Supreme Court reforms. Though court packing has received the most news coverage, there are other proposals that I found interesting and wanted to share in this video. But first, on court packing. It made headlines during the 2020 presidential campaign, but it's been floating in some circles since 2016. That's when Republican senators blocked the confirmation of Obama nominee Merrick Garland and later confirmed Trump nominee Neil Gorsuch. In 2018 and 2020, Congress confirmed Justices Brett Kavanaugh and Amy Coney Barrett, which swayed the court to the right in a 6-3 Republican-appointed majority. That's part of the story, but to understand the background behind court packing, we've got to go back farther than that. The Constitution sets no limits on the size of the Supreme Court, and court size fluctuated during the early 19th century. Sometimes it was because the U.S. had grown larger and added a new district court, and sometimes it was to achieve political goals. That ended in 1869 when Congress passed a law that set the size of the court at 9. And the size of the court hasn't changed since then. There hasn't been significant opposition except in 1937 when President Franklin D. Roosevelt launched a failed plan to add 4 justices to the Supreme Court. So, what are some of the arguments for and against packing the court? Supporters of court packing argue that the court is too partisan and will make overly politicized decisions. They say that adding justices will rebalance the court and safeguard against extreme decisions. Others say that the confirmations of Justice Gorsuch, Kavanaugh, and Barrett are unrepresentative of the will of the people. That's because they were nominated by a president who lost the majority vote and confirmed by a Senate that did not represent the majority of the population. And there are no constitutional barriers. If Congress has enough votes, it can change the size of the court. Some also argue that adding justices will allow the court to expand its docket and address a wider scope of issues. Now, those against court packing argue that it sets bad precedent. If today's Congress adds 4 justices to the court, what's going to stop the next Congress from adding 2 more, or subtracting 3, or from adding another 4? And if Congress continually changed the size of the court, that could undermine the separation of powers, with Congress controlling the political makeup of the courts. Some also say that expanding the court might not expand its docket, because under the court's current structure, each justice works in every case. Court packing has gained traction in Congress, but it doesn't have enough votes to pass in the Senate. So, the spotlight will likely shift to new outlets. So what are some alternatives? For one, there's the Supreme Court Term Limits and Regular Appointments Act of 2020, which proposes 18-year staggered term limits for justices. This bill would require presidents to nominate a new justice every 2 years, and for justices to serve for 18-year terms. Others have proposed expanding the lower courts. This March, Yale Law School professor Samuel Moyn and Take Back the Court director Aaron Belkin submitted a memo that advocated a bill creating 250 lower court judgeships through budget reconciliation, meaning it would require 51 votes to pass in the Senate and not the supermajority of 60 votes. The memo cites data that shows the number of new judgeships has largely plateaued since 1990, while the number of cases has increased by 38%. Moyn and Belkin argue that adding judgeships would relieve pressure and reduce the workload of current judges. Another potential alternative comes from Delaware, which has 2 limits on judicial appointments. The first, known as the bare majority rule, prevents judges from one political party from occupying more than a simple majority of the seats on the court. The second, or major party rule, mandates that judges must be registered as a Democrat or Republican to serve in certain courts. Put into practice, a Delaware Superior Court might consist of 3 Democrat and 2 Republican judges, but no independent or third-party judges. This system could prevent courts from moving to political extremes, but it's met legal challenges, discussed in an earlier video I made on the case Carney v. Adams. The next proposal is a very novel approach. It appeared in the Yale Law Journal in 2018 in a paper by law professors Daniel Epps and Ganesh Sitaraman. Epps and Sitaraman advocate a Supreme Court lottery where cases are decided by random panels of 9 judges drawn from the federal appeals courts. No panel would be composed of more than 5 judges nominated by presidents from one political party, and federal statutes would require a minimum 6-3 supermajority to be overturned. And last, while some advocate change, others want to keep the court as is. One example is the Keep 9 Amendment, proposed in the U.S. House of Representatives last September. The Keep 9 Amendment, as its name suggests, would keep the Supreme Court at 9 justices, preventing future presidents and Congresses from changing the size of the court. Hope you enjoyed learning about some of the proposals to reform the court. Which proposal do you think is best?